seated.
Announcements.
Honourable members, before we proceed with the business of the House today, I have two announcements to make. Firstly, following the point taken by the Honourable Leader of the Opposition at the sitting of Tuesday last regarding the wearing of face masks in the Chamber, I have to inform the House that in view of the coming into operation of the quarantine COVID-19 restriction amendment regulations number 121 of 2023, on 4th September 2023, the wearing of masks in the Chamber is now optional. Honourable members, I have another announcement to make following criticisms, comments made by some honourable members in the media with regard to the handling of questions in Parliament by the Chair. Honourable members, these comments, if not responded to, create the impression that honourable members are deprived of the opportunity to exercise their rights in a parliamentary democracy of putting questions and of doing their work. Honourable members are fully conversant with the provisions of Standing Order 22.2, which sets the time allocated for question time, and same is time bound. Moreover, honourable members have a legitimate expectation that their questions appearing on the notice of parliamentary questions are reached orally. Hence, the Chair has the duty to ensure that a maximum number of parliamentary questions are replied orally within the time prescribed, therefore, which automatically entails a judicious exercise of the number of supplementary questions to be allowed in line with the provisions of Standing Order 26. Now coming to the incident which arose at the sitting of Tuesday last, where the Honourable Asjaveden engaged himself into a vehement argument with the Chair regarding supplementary questions, honourable members will recall that at that material time, I had already announced the list of PQs which had been withdrawn, and also stated that time was over. Therefore, the Chair could by no means entertain the requests of the honourable member and any other honourable member for that matter. Honourable members will also recall that in the midst of that incident, the House had become unruly as MP Paul Béranger and MP Bagwan, who did not have any question standing in their names on that subject matter, deliberately chose to embark on an insulting spree towards the Chair, which was a departure from parliamentary convention and etiquette. As custodian of the privileges of the House, I would have failed in my duty had I not drawn the attention of the House to such derogatory conduct of some honourable members, and the House took the decision to sanction the said honourable members as it deemed appropriate. The honourable members take full responsibility of their overly exaggerated act, which was no doubt tantamount to grossly disorderly conduct, being aggressive, insulting, and contemptuous to the decorum of the House, and also challenge the authority of the Chair. Honourable members, as a Speaker, it is my duty to maintain a level of civility and decorum within the parliamentary setting. Such unbecoming behaviour from honourable members is most regrettable and brings Parliament into disrepute. I, once again, reassure the House that my decisions are always based on the same standing orders and rules, parliamentary practice, and with such authority with which I am endowed. I thank you for your attention.
Papers have been laid. Questions?
Mr. Speaker, my question is addressed to the Honourable Minister of Commerce and Consumer Protection, whether in regard to the supply of gasoline and diesel, she will A, state if consideration will be given for reviewing, 1, respective price structures in order to reduce the retail prices thereof, and 2, procurement method thereof amounting to a total of 16 billion rupees annually, and B, table a copy of the purchase agreement with Mercantile and Maritime Group.
Mr. Speaker, sir, I would like to thank the Honourable Leader of the Opposition for his private notice question, which gives me the opportunity to shed light on this very important subject, because lately there has been a lot of misunderstanding and confusion around this matter, either deliberately or not. Therefore, this PMQ is the occasion to set the record straight and put an end to all the speculations and unfounded arguments being ventilated. Mr. Speaker, sir, I would like to clarify that the contract for the supply of petroleum products is not for the amount of 16 billion rupees, as stated in the question, but for a total premium of 2.6 billion rupees over a year for the supply of about 700,000 tons of products, which comes to a premium of about 3 rupees per litre. Mr. Speaker, sir, the State Trading Corporation was incorporated in 1982 and started the importation of petroleum products in 1983. During its first year of operation in 1983, the STC's portfolio was enlarged by taking over 25% of the petroleum products imports, which until then had been fully controlled by the local oil companies. In 1984, the STC's share of petroleum imports was increased to 50% in the light of the significant savings in foreign currency and the positive impact on the balance of trade and the relative success in the stabilization of petroleum products prices. In the following year, in 1985, the STC was entrusted with the full import of petroleum products, and the local oil companies confined to the role of marketing distribution only. The price structure for mogas and gas oil is defined under the Consumer Protection Regulation 2011, the control of price of petroleum products. It is updated following each exercise undertaken for the fixing of the prices of mogas and gas oil. The detailed price structure is available on the website of the STC. The current price structure of mogas and gas oil comprises the following components: excise duty and VAT. Mr. Speaker, sir, mogas and gas oil are subject to 2 taxes, namely excise duty and VAT. These taxes are collected by the Mauritius Revenue Authority, the MRA, and remitted to the Consolidated Fund. The revenue collected from these taxes are used to finance both recurrent and capital expenditure of government. Mr. Speaker, sir, one of the objectives of this government is to redirect resources towards the needy segment of the population. Each rupee collected from taxes is given back to the population. In fact, with the taxes collected, we are maintaining the welfare state by providing, amongst others, free education at all levels, from primary to tertiary level, and soon it will be extended to the pre-primary level. Free transport for our elderly and students, free health services, monthly pension to our elderly and other vulnerable groups of a society, such as widows, orphans, and disabled persons. The contribution charged to consumers in the price structure are collected to meet social obligations towards the population. These contributions existed in the past, and we have maintained them. Contribution to the Road Development Authority. This contribution is used to part finance RDA's administrative expenditure, as well as to compensate public bus, both companies and individuals, for increase in fuel price and salaries with a view to maintain the bus fares. Any increase in the bus fares will have cascading impact on all sectors of the economy and may halt the increase in our economic growth trajectory. This contribution was introduced in September 1990. I am further informed that the contributions to these items were increased on several occasions, namely in October 2004, January 2006, April 2006, and July 2006. Contribution to roadworks, transportation, and storage. This contribution is used to subsidize the cost involved in transporting, storing, and distributing petroleum products, ration rice, flour, bag cement, and other products. The objective is to protect our brothers and sisters in roadworks so that the retail price in roadworks are kept at par with those prevailing in Mauritius. I am made to understand that this contribution was introduced in September 2000. Contribution to the construction of storage facilities for petroleum products. This contribution is for the construction of warehousing facilities for the storage of petroleum products. This item was introduced in November 2015. The rate is 65 cents per litre for mogas and 50 cents per litre for gas oil. From the funds collected, 75 million rupees have been invested in the construction of a storage facility, namely Mer Rouge Oil Storage Terminal, which has a storage capacity of 25,000 metric tons, out of which 15,000 metric tons is meant for mogas and 10,000 metric tons for gas oil. This has increased the buffer stock of the country by 30 days for mogas and 16 days for gas oil. In July 2021, an amount of 800 million rupees was transferred to the price stabilization account to avoid an increase in the retail price of mogas and gas oil. As at 30 June 2023, the balance of this contribution stood at 790 million rupees. Mr. Speaker, sir, the war between Russia and Ukraine, and now the disastrous situation which is developing in the Middle East concerning the war between Israel and Palestine, have brought to light the great risk of disruption of supply chain, including the movement of tankers of petroleum products. This clearly indicates that anything can happen at any time, with serious impact on prices as well as movement of products. This is a clear indication that the country should get ready to face such a situation if it arises. Given that Mauritius is a small island and the country relies entirely on importation for the procurement of petroleum products, this fund is earmarked for the construction of additional storage facilities for petroleum products to ensure security of supply. Contribution to subsidy on LPG, flour and rice. This contribution is used to finance the subsidy for the purchase.
10 minutes has already gone by. We are lenient, but 10 minutes has already gone by. She has not even started to answer the question.
I'm going to start soon.
I hope that you will give...
Don't worry.
She agrees that she has not started to answer the question.
No,
I hope
I'm
that
coming to it.
That you will give extra time at least.
This item was introduced in April 2007. Our population is still benefiting from the subsidized price. On a 12 kg cylinder of cooking gas at the price of 240 rupees instead of the market price of 499 rupees. That is 52% lower than the market price. On rice, at the price of 10 rupee 80 per kilo, instead of a market price of 17.46 rupees per kilo. That is 38% lower than the market price. And on flour, at the price of 2 rupees 18 per half kilo to bakeries and 4.85 rupees per half kilo to non-bakeries, instead of a market price of 15.87 rupees per half kilo. Mr. Speaker, sir, it is noted that even with this contribution, which totals to around 3.7 billion rupees, government spends not less than 4.1 billion for all these subsidies. Mr. Speaker, sir, the price structure also provides for retail and wholesale margins to cover the operating costs for the distribution and retail of petroleum products by oil companies and petrol stations around the island. The revenue derived from each contribution is collected by the STC and remitted to the relevant authorities. Mr. Speaker, sir, all of the components of the price structure have been introduced in order to maintain affordable prices for essential commodities so that they are accessible particularly to people from the lowest income group. I am further made to understand that collection of taxes and other contributions from the sale of petroleum products is a general practice in most countries. It is actually a progressive collection of funds wherein those who use more are required to contribute more. It is a dynamic item and can be subject to review with time, depending on prevailing economic and social conditions. It would be, therefore, presumptuous at this stage to take a stand as to whether we will review the current price structure. Mr. Speaker, sir, it might be particular to state that removal of items would bring down the price of petroleum products, but we need to ask members of the other side of the House why they did not do it in the past, and also how we would continue financing the welfare state without these contributions, unless the members of the opposition are suggesting the removal of the financing of subsidy for the vulnerable segment of the population. This is not the policy of this government, which will ensure that at all times the vulnerable are cared for. Mr. Speaker, sir, with regard to part 2 of the question, I am informed that the State Trading Corporation launched on the 5th May 2023 an open international bid on the government e-procurement system for the supply of 4 grades of white oil, namely Mogas, gas oil, jet A1, and marine gas oil for the period 1st August 2023 to 31st July 2024. At the time of opening, 7 bids were received, and an evaluation exercise was carried out to determine the lowest responsive bidder. Eventually, this tender exercise was cancelled in view of a better offer received from Mercantile and Maritime Investment Private Limited, which included a more competitive premium price for all the 4 categories of products and other benefits not proposed by the lowest responsive offer. And in the tender exercise, I wish to highlight the fact that the STC is exempt from the provision of the Public Procurement Act since 2008 with respect to the purchase of goods for resale, including services incidental to the purchase or distribution of such goods. The STC may thus engage in direct purchase and/or negotiation with a seller for goods it purchases for resale, including white oil. Mr. Speaker, sir, the benefits that were to be reaped from the offer made by Mercantile and Maritime Investment Private Limited included, number 1, a lower premium that would enable saving of approximately 460 million rupees over the term of a 1-year contract, an improved cash flow for the STC based on the credit period of 60 days from the discharge date, allowing it to benefit in terms of interest costs payable to banks. Thirdly, a performance bond value of 15 million USD to be placed in the bank account of the STC to be called upon in case of non-performance in favor of the STC. Possibility of making payments to Mercantile and Maritime Investment Private Limited in Mauritian rupees instead of US dollars. Due to the negative impact of COVID-19 on the Mauritian foreign exchange, the forex market, the STC was facing difficulties in obtaining the required amount of US currency to pay its suppliers. Therefore, such an arrangement with Mercantile and Maritime Investment Private Limited would significantly reduce the USD requirements of the STC, which would in return lower the estimated interest cost of 250 million rupees payables to commercial banks. And lastly, US currency being made available for purchase by traders on the local market, as STC being one of the major USD buyers on the local market would not require same for payment to Mercantile and Maritime Investment Private Limited. Mr. Speaker, sir, in view of these benefits, the STC cancelled the tender exercise as per clause 21 of its bidding document, which inter alia reads as follows: that the STC reserves the right without thereby incurring any liability to bidders to accept or reject any bid and to annul the bidding process and reject all bids at any time prior to contract award. Following board approval obtained on the 29th June 2023, the STC proceeded with the allocation of a contract to Mercantile and Maritime Investment Private Limited. Mr. Speaker, sir, as regard to due diligence exercise, I am informed by the STC that it had carried out a due diligence exercise on the company and obtained its certificate of good standing, certificate of incorporation, and latest audited financial statements. The financial soundness of Mercantile and Maritime Investment Private Limited, incorporated and domiciled in Singapore, was assessed based on the audited financial statements for period ending 31st December 2021. The financial statements have been audited by UHY, Lee Sang Chan and Company, a Singapore and Co., a company, a Singaporean audit firm with more than 50 years' experience in auditing and other advisory services. In addition, a compliance check was carried out to assess the potential financial, regulatory, and reputational risks of the company. Mr. Speaker, sir, I am also informed that as per clause 19 of the present contract with Mercantile and Maritime Investment Private Limited, each shipment needs to be accompanied as a mandatory condition by a certificate of origin of a petroleum product to assess that same has not been procured in no way from a country under sanction by the United States, by the United Nations, the European nation, the United States of America, amongst others. This certificate has to be produced prior to arrival of the tanker. Mr. Speaker, sir, I am also informed by the STC that Mercantile and Maritime Investment Private Limited is an experienced energy market operator incorporated in Singapore, providing international clients with a full range of services across the oil and gas value chain. It is specialized in the trading of physical oil and gas products, shipping and logistics, midstreams. The company has traded over 400 million barrels of crude and over 300 million barrels of oil products. Mr. Speaker, sir, as regard to the last part of the question, I wish to inform the House that the contract is a live one, and the Leader of the Opposition will concur that such major contracts are governed by a standard confidentiality clause. In order to render same public, we would need to have the concurrence of all parties involved under the contract, and unfortunately, we have not the time to consult the Mercantile and Maritime Investment Limited on same.
Order.
Mr. Speaker, I am shocked by the last part of the Minister's answer, but I will also tell her that she's mistaken in terms of the contract for the purchase of petrol. You don't just pay MMG for the premium, you also pay them for the fuel they bring. Otherwise, they'll fight. So actually, the contract we paid to MMG is 16 billion rupees, and I'm sad that she didn't know that. Still, let me come to the first part of my question concerning the price structure. Now, one item, the price structure, has has increased substantially. It is a contribution for subsidy on rice, flour, and LPG. Now, there are two ways of dealing with this. One, either you put it in the consolidated fund, and the taxpayer still pays, and the money still, the prices are still low, or you put it in the price structure. But the minister will understand, I'm sure, that putting it in the price structure at 7 rupees 20, it was 2 rupees before, 7 rupees 20, has a cascading effect on inflation, has a cascading effect on other prices, and of course, high inflation also gives high interest rates. So one of the reasons for the high inflation is that the price structure includes items which should have been dealt with elsewhere than in the price of petrol. Do you understand what I'm saying? Why, if I'm asking why she doesn't liaise with her colleague to see that these items which do not need to be in the price structure are dealt with in the consolidated fund?
Mr. Speaker, sir, I do understand what the Honourable Leader of the Opposition is saying, because I too, I've been teaching accounting for the past 27 years. And the contract to is for the supply of petroleum products, hence 2.6 billion rupees. And either it was with Mercantile or any other companies, would have to pay for the petrol. You agree with me, the Leader of the Opposition. So the contract is for the premium. And concerning either we should have put this in other parts, of the price structure. But why you didn't do it when you were, the Minister of Finance, or when you were the Deputy Prime Minister? It was like that. We are not inventing the wheel. It was like that for many years.
I just explained to the Minister it was 2 rupees before. It was manageable. Now it's 7 rupees 20. It's a different issue. And 7 rupees 20 on a litre of petrol is a huge amount of money, Mr. Speaker. Mr. Speaker, I'm sad that she didn't take that into account. I'm going to talk now ask the Minister about the famous price equalization account. With the Minister, I agree that this price equalization account, all it is, in fact, is accumulation of taxes that have been imposed on the price of petrol and diesel, in this case diesel, which have not been able to be passed on to the consumer. And that at no time in the history of Mauritius has petrol been purchased at a higher price than it has been sold. We'll see, therefore, agree that this price equalization account needs to be abolished.
Just give me a minute, please. Concerning the price stabilization account, it was to control the price of petroleum products on the market. And otherwise, we would have to, on every consignment, either increase or decrease the price of petroleum products. And there was also a need to ensure economic recovery following the COVID.
That your answer? I asked you whether you agree that it is accumulation of excessive taxes, yes or no? That is.
No, we are not in a court of law. Yes or no, this is barrister's style. You are leader of the opposition and she's a minister. Let her reply.
No, it is not.
Mr. Speaker, I have to laugh. Mr. Speaker, I'm going to ask the Honourable Minister now. I'm going to ask the Honourable Minister now as to this contribution to construction of storage facilities, which up to date has collected 1.6 billion rupees from the sale of petrol, and the amount actually invested by the government in the Mauritius oil storage facility, most, is in fact 76 million rupees. So the excess amount claimed from the consumer of petrol has in fact been claimed wrongly from the consumer. Therefore, will she agree to abolish this tax, which has already led to some 1.6 billion rupees entering into the coffers of government?
Mr. Speaker, sir, I just mentioned the importance of these storage facilities. I just mentioned that it is something very important. Due to war in Israel and other countries, in Ukraine, we have to ensure that in case something happens, that there is enough supply of petroleum products on the market. So it's a very important element. We can't abolish this.
It's been going on.
Excuse me. And out of 16.6 billion, 800 rupees was put back in the PSA.
800 million rupees was put back with the CSA and criticized by the Director of Audit because it was illegal. You forgot to mention that bit. Mr. Speaker, let me ask the Honourable Minister concerning this unsolicited bid that was received from the company MMG. It's an unsolicited bid after MMG took account of the result of the tender that happened, which was a public tender. The figures were open. MMG then offered a lower price. Why didn't the minister then either relaunch the tender, or the minister or her predecessor, I'm not sure who it was, relaunch the tender, or enter into a reverse auction, which is available, as you may know, in the e-procurement system of the Ministry of Commerce?
Yes, Mr. Speaker, sir, what MMI proposed, MMG, right, was a very good deal for the country. Because with this, we have managed to save more than...
Allow the Minister, please. Decorum, allow the minister, allow her to finish with her reply.
We have managed to save more than 700 million rupees with this contract. And, time was of essence. It was a good deal, so we took the deal. Because I gave you a list of, benefits that we were getting from this company.
I mentioned to the minister the possibility in her own e-procurement system of a reverse auction where people can drop the price as much as possible, which would have allowed the other 7 to drop their prices if they wish to.
In fact, Mr. Speaker, sir, was the only companies who...
Maybe I should ask you the question, not her.
In fact, Mr. Speaker, sir, MMG was the only companies which accepted to be paid in 2 Mauritian rupees. That's why we go for it. And I've given all the, the benefits that the country is going to derive from this contract.
Mr. Speaker, the question of the contract being made public is extremely important. As she will know, the tender document, the original tender document of May, is a public document. The bids that the tenderers make are also public and published by the ministry on the e-procurement system. Why is the famous deal with the MMG kept secret? Are we not to know what are the product specifications? Are we not to know at what rate of conversion the rupee, the dollar is going to be converted so that MMG are paid? Are we not to know all the details about this, the credit terms? You say it's 2 months. This is what you say. But unfortunately, Mr. Speaker, this House has seen Molnupiravir, has seen packet blister, has seen the problems with the STC, and we do not trust.
Stick to your question. Reply, Minister.
Mr. Speaker, sir, no other suppliers provide us such facilities for payment. We got 2 months credit. And also, we got to pay into Mauritian rupees, allowing us to save also 250 million interest, but otherwise should have gone to pay to the banks. So it was a very good deal. And then maybe for you it's peanuts. Maybe for you it's peanuts, because we've seen that in 2 coffers there were 220 million kept at home. Maybe it's peanut for you. But for the population, it's for the population.
Order.
Mr. Speaker, I
haven't completed. I haven't finished my reply. And every saving is important after this period of COVID. Every saving, even 1 cent, is good for the country. So we had to accept this deal. It was a very good deal for the country.
Minister who doesn't know about the cost of the contract, who doesn't understand what is the price equalization account, who doesn't know anything about reverse auction, I found her attitude surprising. I'd like to ask the minister. She doesn't know yet. She is
Put your
anyway.
question. Don't make insinuation. Put question.
You allowed her to make
Time
insinuation.
is already over.
Time is over because she took 22 minutes, Mr. Speaker. That's why time is over.
Continue.
Mr. Speaker, I'd like to ask Honourable Minister. I had my doubts about this NMG. Now that she's refusing to publish the information, to publish a contract, I and many people in Mauritius will be compelled to believe that there is anguille sous roche
in that contract, and that is why she is not publishing it.
Mr. Speaker, sir, I have not refused to publish the contract. I've said that there is a confidentiality clause, right? And we need to get the agreement of both parties. And the Honourable Leader of the Opposition, as an accountant, he knows nicely the confidentiality clause in any contract. Thank you, Mr. Speaker, sir.
Last question. Would your last question?
Yes, Mr. Speaker. This is the question I'm going to ask her. If you consider the price of petrol in Mauritius, it's at $1.6 per litre. I'm talking about Mogas. And this is approximately the same amount that the UK consumer or the European consumer will pay for their litre of petrol. Yet the salaries of these persons are about five times. About five times the price, the salary of the Mauritius.
Leader of the opposition, I am on my feet. Respect decorum in this house. I am on my feet. You have no right.
What am I doing wrong?
I should give you permission to continue with your question only. No comments. Question.
What am I doing wrong? Are you asking her whether she's aware?
Put your question, no comments. Last question. Time is going.
I will put my question again. Last question. Given that the price of petrol here, the retail price of Mogas, is equivalent to $1.6 per litre, this compares about the same to what a European, USA it's even cheaper, European or English consumer is paying. And does she know that these consumers earn about 5 times more on average than the Mauritian? Will she agree?
Leader of the opposition, I don't allow this question. This is demagogy. This is demagogy. This is not factual. This is demagogy from your part. I don't allow this question. If you want to reply to the first part, it's okay. The second part is demagogy.
Yes. You know, I want to reply, Mr. Speaker, sir.
The first part you may go.
Yes, the first, yes. You know, Honourable Mr. Speaker, Honourable Leader of the Opposition, we have to compare like with like. This is what I teach to my students in accounting. We have to compare like with like. And you're comparing us with, UE consumer highest, with highest pay and all. Why don't you compare us with Seychelles, our neighbor just close by, and see how much they are paying?
Order.
You see?
Order. Decorum. Order. Parliamentary democracy. Carry on, yes. Honourable Minister.
So we have to compare like we like, Mr. Speaker, sir. Okay, and we cannot compare ourselves with countries who are producers. Thank you.
Time over. Honourable members, the table has been advised that PQB 1256 will be replied by the Honourable Prime Minister, time permitting. Prime Minister's question time. Honourable Tim.
B 1240.
Mr. Speaker, sir, this question relates to issues falling under the purview of the Security Division of the Prime Minister's Office, which deals with national security. It would not therefore be appropriate for me to disclose information pertaining thereto. Mr. Speaker, sir, I wish to emphasize that it has always been the practice in this House not to disclose such information, and successive governments have since independence adhered to this principle scrupulously. However, I wish to reassure the House and the Honourable Member that all the procurement exercises in question and the disbursements in relation thereto have been carried out in full compliance with the applicable laws, rules and regulations.
May I know from the Honourable Prime Minister, if everything has been done, as he said, in accordance with the law, why is it that the Financial Intelligence Unit has applied for a restriction order to freeze the bank account of DNS International Limited because they represent proceeds of a crime? All these monies paid with the government there was an application to freeze those monies.
Well, Mr. Speaker, sir, this is not in relation to this question. The Honourable Member is talking about a case which is actually pending before the court. And he wants me to comment on a case which is actually pending before the court. I think he is a lawyer, he should know better than anybody else. Now, I don't want to go into the detail, but is the Honourable Member saying that the restraining order concerns only this, any payment that has been made? I think he knows the case quite well, and he should know better that you have to not to try to mislead the population with regard to what is being before the court and with regard to this question.
The judgment is in the public domain. In the judgment, the learned judge of the Supreme Court set out extensively all the contracts, the terms of contracts awarded by the Security Division to the DNS International for the purchase of equipment from Verint System Limited, an Israeli company which, according to its website, specializes in interception of vocal messages. So may I know from the Honourable Prime Minister, being given that, according to the judgment, above $15 million, more than 650 million rupees has been paid to Verint for these voice intercepting messages, whether these equipment have been used, and if they have been used, whether a judge's order has been obtained before making use of these equipment.
Mr. Speaker, sir, let me remind this honourable member, maybe he's not aware, I think, and it's good that I remind him of the past practices. And I say since a very long time ago. Let me refer him to a question that was put at the sitting of the 22nd of June 1971 at the committee stage by Honourable Olivry at that time. The question was about increased provision of the special branch. And the minister who replied, Honourable Yusuf Mohamed, I quote, "The information my honourable friend is searching for is secret because it happens to be the secret police. C'est la police secrète." I refer him now to a sitting of the 21st of July 1992, a question put by Dr. Honorable Bulel to Sir Anirudh Jagannath, Prime Minister, who replied, "At any rate, sir, the NIU being responsible for state security, it would be neither appropriate nor proper in the interest of security to debate any question relating to it in this August Assembly. This is a convention which has existed since independence concerning our intelligence service, and any government should observe it scrupulously." The sitting of the 15th of July 1997, a question put by Honorable A.B. Juval and being replied by Honorable Rajkeshwar Paryag, then Deputy Prime Minister. And I only quote what is relevant because the Honorable member was asking about National Intelligence Unit and so on. It would not be in the interest of security to disclose the breakdown of the expenditure incurred. A question that was put by Honorable Jiwa, During the Appropriation Bill 1997-1998, question was about providing details with regard to the amount to be voted for, again, for security issues. And Dr. Navin Ramgoolam, Prime Minister, replied that he did not give any detail concerning the sum to be spent for each project or for the different items. Sitting of 24th of June 2003 at committee stage, Dr. Honorable Boulel asked a question about running costs of the security unit. Honorable Paul Béranger, acting Prime Minister, replied, "This is a case where I am sure the former Prime Minister will agree with me. In matters of security, we have to be very discreet, so I won't go into a lot of details." A sitting of 7th of December 2010, committee stage, again, question put by Honorable Lejongar about acquisition of CCTV street surveillance system for Grand Bay and Port Louis. Acquisition of CCTV system, Mr. Speaker, sir. Dr. Navin Ramgoolam replied, "I can't give details about security matters, but it will be manned properly." Again, at the sitting of the 21st November 2011 at committee stage, I put a question at that time about counter-terrorism unit, about security unit. And Dr. Navin Ramgoolam replied that where are they based? In fact, we need to find a different location. Now, they are meeting in places which have to be kept obviously secret. But we think we need at least have a place where nobody will know these people work in that unit. And another, at the sitting of the 25th of June 2018, question put by Dr. Honorable Boulel, National Security Services. Again, the Prime Minister replied, the information pertaining to national security is by nature classified. It cannot be divulged. And at the sitting of the 24th of June 2019, Honorable Bhagwan had asked a question about national security. The Prime Minister replied, we all know with regard to the national security services, we normally do not provide information. So, Mr. Speaker, sir, it has been a tradition throughout by all governments, not to answer or give details with regard to security matters or matters which have to be kept secret in the public interest.
So, you still have a question?
Yes, I'm not asking the Honourable Prime Minister to divulge any national security interest details, but being given that we also have a right, a constitutional right to privacy. May I know if the Honourable Prime Minister is prepared to give the assurance to this House that these equipment that has been bought for national security purposes will not be used to spy on political opponents without a judge's order.
Mr. Speaker, sir, let me reply. I think the honourable member is getting confused, really confused, because he has put a question to ask about aggregate value, about procurement method, and about equipment purchase. Now he's coming to another issue completely, whether there is phone tapping, listening, and so on. I think he's lost.
So the question has been sufficiently canvassed. We move to the next question.
B 1241.
Mr. Speaker, sir, I wish to thank the honourable member for this parliamentary question, as it is one of national interest, and it gives me the opportunity to inform the House and the population at large of the rationale behind this measure. and the need for all users of mobile phones, including the business community, tourists, visitors, and the population, to ensure compliance with the Information and Communication Technologies Registration of SIM Regulations 2023. Mr. Speaker, sir, the House would recall that in the report of the Commission of Inquiry on Drug Trafficking, chaired by the former judge of the Supreme Court, Mr. Pol Lam Shang Ling, and published in July 2018, observations were made at paragraphs 3.26 and 3.28 relating to the misuse of subscriber identity module cards, which are as follows, and I quote, paragraph 3.26, entitled Black Phones. The Commission also heard the use of black phone by persons whose real identity could not be traced out, and the SIM cards belonged to foreigners who had either left the country or the registered owner had passed away, and yet the SIM cards were still active and in circulation, and there was no change in their ownership. End of quote. And I refer again the House to another paragraph, 3.28, ICTA, need to think out of the box. I quote, the Commission was appalled to hear of the sale of 200 SIM cards at one go to an employee of a travel agency who had more than 25,000 SIM cards registered in his name, and who confessed that he was oblivious of the danger and shocked with disbelief when he was informed that some of the SIM cards registered in his name were seized in prisons. The Commission also has evidence that some of the SIM cards registered in the name of foreigners, mainly from Bangladesh, who had left the country, were used in prisons to communicate with accomplices outside and with barristers. The authorities concerned must have proper monitoring of satellite phones as information gathered from the ADSU traffickers are using them. End of quote. Furthermore, at paragraph 11.8 of the report, the following recommendations were made to address the issue of misuse of SIM cards, and which I quote, in view of the heavy dependence of the drug traffickers in the prisons on smartphones, the Commission is of the view that the relevant authority, together with the telephony service providers, must review the sale of SIM cards, especially to tourists and foreign workers. Regulation must be made so that any person wishing to obtain a SIM card must personally fill in the application form with all relevant information to identify and locate the person, and only one SIM card can be given per application to prevent corrupt seller of SIM cards in tobacco outlet to insert more SIM card numbers without the knowledge of the applicant. SIM cards issued to foreign visitors must have a period equivalent to their stay, and thereafter automatically deactivated by the telephony service providers. The Commission has also noted the ease with which the drug traffickers could obtain credit to enable them to use their smartphones. Topping up of SIM cards by using scratch cards must be forbidden. It is for the authorities to find other means to enable their clients to be able to continue using their telephones. With the postpaid system, there will be greater control as the telephony service providers will have to send their invoice at a particular address and if the amount is not settled within the specified period, the service provider will be entitled to cancel the use of that number which it is actually doing. The Commission heard of the traffickers now resorting to satellite phones. The relevant authority must supervise and control that type of phone, unquote. Following the report, my office, together with the Information and Communication Technologies Authority, held a series of consultations with the various stakeholders concerned, including, among others, the Attorney General's Office, the Police Department, the Ministry of Information Technology, Communication and Innovation, the Ministry of Foreign Affairs, Regional Integration and International Trade, the Passport and Immigration Office, the Bank of Mauritius, the Data Protection Office, as well as the free mobile operators in Mauritius, to explore the possible measures to be taken to address the issues relating to the misuse of SIM cards, thus such as the purchase of SIM cards through impersonation, usage of these cards to carry illegal activities such as criminal intimidation, extortion, unsolicited calls, and drug trafficking. Mr. Speaker, sir, the ICTA also took into consideration the best practices which have been implemented in other countries. For example, India has implemented strict regulations and procedures for SIM card activation, including mandatory biometric identification. It is also noted that Germany has mandatory identity requirements for SIM card registration to prevent misuse, whereas the objective of the registration requirement in Australia is also to enhance security and track potential fraud. Hence, on the basis of international best practices, the ICTA developed a legal framework to address the issue of misuse of SIM cards, and following which it held discussions with government institutions, regulatory authorities, enforcement agencies, and the mobile telephony operators. These deliberations resulted in the preparation of the Information and Communication Technologies Registration of SIM Regulations 2021, which also took into consideration some of the views submitted by the telephony operators. The said regulations were thus promulgated on 31st December 2021, with effective date of operation on 1st April 2022, to provide the free local operators, namely Mauritius Telecom, MTEL, and MTML, a 3-month period to set up the required infrastructure and database for the implementation of the regulations. Hence, the current holders of SIM cards would have registered their SIM cards not later than 6 months, that is by September 2022, after the coming into operation of the regulations, failing which their cards would have been deactivated. Mr. Speaker, sir, following the promulgation of the regulations in December 2021, the ICTA had several technical meetings with the operators and other concerned stakeholders for the smooth implementation of the project. However, during these discussions, several technical problems were identified. These problems related to the setting up of a middleware system at the ICTA and the upgrading of the respective IT infrastructure of the operators. Consequently, the ICTA informed my office that due to these advanced upgrading works required to the existing systems of certain stakeholders, including the operators, additional time would be required by them for the efficient implementation of the regulations. In light of the technical problems encountered by the operators, government agreed to postpone the coming into operation of the regulations from 1st April 2022 to 31st October 2023, and the deadline for the registration of all active SIM cards from September 2022 to 30th April 2024. Mr. Speaker, sir, the Information and Communication Technologies Registration of SIM Regulations 2023, which takes into account in a comprehensive manner all the recommendations pertaining to the misuse of SIM cards in the report of the Commission of Inquiry on Drug Trafficking, provide for a technology-driven mechanism for the registration of SIM cards with focus on traceability on the SIM card owners and mitigation of risks of malpractices. These regulations provide, among others, that all SIM card holders must register their SIM card in person or online by providing, amongst others, mandatory documents such as the national identity card or passport details and recent utility bills to verify proof of address. Service providers will also be required to take the colored photograph of the applicant for the online real-time verification of the subscriber's identity. Clearly defined processes for registration of SIM card for different categories such as tourists, non-citizens residing in Mauritius, corporate entities, public institutions, and diplomatic missions. A public body, corporate body, company, diplomatic mission, or any other organization being SIM card owners should register the end user, that is, its employees, as the subscribers. Furthermore, these entities can change the subscriber in case an employee leaves the organization or in case of death of the employee. There will be a distinct numbering plan for SIM card to be used by tourists and machine-to-machine SIM cards. A new numbering plan would be applicable for tourists to demarcate their SIMs from that of citizens. Only holders of a tourist enterprise license or tourist accommodation certificate may buy SIM cards on behalf of tourists. The SIM card is activated only when the subscriber proceeds with the registration as per the regulations and after successful online real-time verification. SIM cards issued to tourists will have a period of validity equivalent to their visa, and thereafter will automatically be deactivated by the service providers following their departure from Mauritius or cancellation of visa. In case of death of subscribers, the SIM card will automatically be deactivated within 15 days from which the death is recorded by the relevant authorities. A parent or guardian would have to produce his own national identity card and photograph at the time of registration of SIM card for his child. And a subscriber would be required to report the loss of his SIM card to the police within a period of 48 hours. Mr. Speaker, sir, registration is mandatory upon purchase of a new SIM card. Current SIM card holders also need to re-register as from 31st October 2023. Those who should re-register as from that date are citizens of Mauritius, non-citizens residing in Mauritius, corporate bodies, and government institutions. It is to be noted that for registration and re-registration purposes, appropriate identity documents should be presented as follows. For Mauritian citizens, national ID card, personal details of passport, recent utility bill, or any other proof of address. For non-citizens, personal details of passport, unique identification number, residence permit or occupation permit, recent utility bill, or any other proof of address. For tourists, personal details of passport or any other valid travel document and proof of address in Mauritius. And machine-to-machine SIM, a letter from the organization authorizing a person to act on its behalf, a national ID card or personal details of passport for the person acting on behalf of the organization, recent utility bill of the organization or any other proof of address, and copy of the certificate of incorporation of the organization. I am also informed that with a view to facilitating the process, re-registration of SIM cards would be possible, both remotely, that is, through the internet, on the applications developed by the mobile operators, and at any service operators' outlets, free of charge. Mr. Speaker, sir, with regard to part A of the question, I wish to inform the Honourable Member that the rationale of coming up with these regulations is to allow traceability, mitigate the risks of malpractices, and reinforce security of the telecommunication sector. Accordingly, both the new registration and re-registration processes would be an important step to allow the operators to authenticate and validate details of their subscribers through 1. Real-time verification of applicant details, and 2. Conducting liveness tests and image check where the applicant is applying for registration and re-registration remotely through the internet. As regard part B of the question, I am informed that the re-registration of the SIM cards will apply to all SIM cards holders, that is, citizens of Mauritius, non-citizens residing in Mauritius, as well as postpaid and corporate customers. Mr. Speaker, sir, concerning part C of the question, I am informed that for the efficient implementation of the regulations, it is of paramount importance that a reliable and genuine database of SIM card owners be put in place and maintained. In this respect, a middleware system has been installed by the ICTA at the Government Online Center to act as an interface between the operators on one side and the Passport and Immigration Office and the Civil Status Division on the other side. Through this interface, the operators would be able to verify on a real-time basis the name, the national identity card number, and the date of birth of a citizen with a Civil Status Division. On the other hand, for tourists and non-citizens residing in Mauritius, the operators would have the possibility to check the validity of the visa, the passport number, and the unique identification number with the Passport and Immigration Office. As such, upon the departure from or overstay of tourists in Mauritius, operators will be notified accordingly through the interface, following which they will proceed with the deactivation of the SIM cards on the following day. This will prevent the usage of these SIM cards by other persons after the departure of the tourist or overstay of same, as may be the case presently. Mr. Speaker, sir, as I have already stated, the re-registration of existing SIM cards will start as from 31st October 2023, and users will have a period of 6 months, that is up to 30th April 2024, to complete registration of their SIM cards. Presently, there are 2,339,017 active SIM cards in Mauritius, 56,016 in Rodrigues, and 1,036 in Agaliga, to sensitize all SIM card holders on the new regulations and the need for a timely registration of their SIM cards, failing which their SIM cards will be deactivated. The ICTA has already launched its communication campaign since the 4th of October 2023, which will be ongoing till 30th of April 2024 on print, broadcast, and online media. For this purpose, the services of a public relations agency has been retained to conceptualize and conduct the campaign. This campaign is being conducted in 3 phases. Phase 1, the soft launch, which started on the 4th of October in 2023 through the focus program on the MBC, and will be ongoing for a period of 1 month, whereby the focus will be on the need to inform subscribers to re-register his or her existing SIM cards. ICTA has also issued a communiqué on the 18th of October 2023, and a frequently asked questions sheet has been posted on its website. Moreover, ICTA has also intervened on private radios. Phase 2, to start as from 15th of January 2024, and will take into account the number of re-registration done during the past month, and the campaign strategy will be adjusted accordingly. And phase 3, the emphasis will be to encourage subscribers who have not done so to re-register before the 30th of April 2024. Mr. Speaker, sir, I take this opportunity to invite all SIM card holders residing in our Republic to start re-registering their SIM cards as from 31st of October 2023 as a positive action towards mitigating the risk of the misuse of SIM cards in illicit activities. I eagerly encourage all concerned citizens to re-register their SIM cards as early as possible in order to avoid last-minute rushes. Thank you.
Mr. Speaker, sir, after this quite detailed and lengthy answer from the Honourable Prime Minister, I would like to state that we, of course, all support all efficient actions meant to fight drug trafficking. Yet, may I ask the Prime Minister how this tracing system is meant to work when drug traffickers in Mauritius will simply use foreign SIM cards and use mobile internet applications for communication?
Mr. Speaker, sir, the fact that, true it is, somebody can use a foreign SIM card. Does that mean that we don't take action here? Does that mean that we don't follow the recommendations that have been made by the Commission of Inquiry on Drug Trafficking? Does that mean to say that, well, we just pay lip service to... And it is, in fact, the opposition who have been criticizing us unjustly, for trying to make people believe that we are not implementing the recommendations of the Commission of Inquiry on Drugs, when we have been implementing the majority of those recommendations. And this is, I have extensively, purposely given all the details, quoting the relevant parts of the report on the Commission of Inquiry and the recommendations that have been made by the Judge Lam Shangling. And now that we are implementing this recommendation, we are being told, well, there is a possibility that somebody can use a SIM card from outside, from another country, and therefore what should we do? What should we do? May I ask the Honourable Member, what should we do? We just sit down and relax? But, Mr. Speaker, sir, irrespective of what the Honourable Member is saying, as a government, as a responsible government, and as a government which is meant to fight against drug traffickers. We are taking all the necessary measures in order to see to it that we see to it that we are able to plug whatever loophole there can be. This has been a loophole, I agree, as the report has said, this has been a loophole for quite some time, and we are plugging now this loophole.
The Honourable Prime Minister mentioned indeed this report of a Commission of Inquiry on Drug Trafficking. This report was submitted in July 2018. I understand that there has been some technical issues. Still, may I understand why is it that it took almost more than 5 years to the government to implement such measures, and a few months now up front the coming general elections?
Well, Mr. Speaker, sir, we are not implementing the measures that have been recommended by on the report of the drug trafficking because the elections are coming. We started the very next day, but there is a process. You must understand, we set up a committee to look into all the recommendations. We had all the ministries concerned, all the stakeholders to be involved with regard to what recommendations. First of all, there are, I must say, there are a few recommendations that cannot be implemented. But I again say most of the recommendations have been implemented. And this has taken some time, yes, because there are a number of technical issues that had to be dealt with. I have mentioned in my answer the number, I have not mentioned the number of meetings, but I mentioned that there have been consultations with the stakeholders, especially with the telephony service providers, and there are a lot of issues that had to be addressed. And we have come now to a stage where now we have amended the law, and the law is being applied. So let us look at the good side and not criticize and to say that I think you will agree that we need to act against people who are bent to commit offenses, and particularly serious offenses like drug traffickers.
Thank you, Mr. Speaker, sir. In view of the reply provided to the main question, can the Prime Minister provide assurances with regard to the security of personal data of those 2.4 million subscribers? Thank you.
Yes. Mr. Speaker, sir, I am informed that personal data of subscribers are and will continue to be collected and stored by the mobile telephone operators in conformity with the Data Protection Act. The ICTA does not and will not have access to those personal data. The ICTA will act only as a technical interface between the mobile telephone operators and the databases of the Civil Status Division and the Passport and Immigration Office. I am also informed that the connections of the online verification system between the different stakeholders, namely the Civil Service Division, the PIO, the ICTA, and the mobile operators, will be secured and the information exchange will be encrypted. And it is important that I highlight once more that there will be no database at the ICTA, and therefore there will be no possibility for personal information to be retrieved at that level for any use whatsoever.
Time over. Question to other ministers?
44.
Mr. Speaker, sir, as from 1987, when the first HIV case was registered in Mauritius, multiple factors intertwined with other complexities have changed the trend of HIV epidemic throughout the time. These anticipated changes resulted in my ministry being proactive in adopting and implementing required intervention strategies. The HIV screening has been tailored accordingly and adopted to each specific group, namely the key populations comprising people who inject drugs, men who have sex with men, female sex workers, and transgenders, and other vulnerable groups, as well as the population at large, and newborns infected through mother-to-child transmission. The HIV epidemic since early 2000 is concentrated among key populations. Expanding awareness, prevention, and behavior change interventions focused have always been on the key populations to slow and eventually curb the epidemic. The bold measures implemented were effective, as evidence shows that the HIV prevalence is on the decline among the key populations. Despite these advances, there are barriers at multiple levels that prevent optimal utilization of the HIV services. This calls for strategies that target and address these barriers. Mr. Speaker, sir, the data as from 2017 shows that the trend in incidence of HIV epidemic has changed in the mode of transmission from bloodborne through sharing of needles and syringes to heterosexual contact. Multiple measures go back on track, have been implemented to fill in the gaps in the HIV program. One of them is the setting up of the multi-sectoral HIV coordination committee at my ministry to ensure meaningful engagement of all stakeholders involved in the fight of HIV. Moreover, a comprehensive national HIV action plan has been developed to address the challenges for engagement of all relevant stakeholders involved in the fight against HIV. Mr. Speaker, sir, another measure put in place as from November 2020 has been the scaling up of HIV testing through provision of HIV testing at accident and emergency departments of all regional hospitals. For HIV prevention of mother-to-child, HIV tests are carried out during early pregnancy. Retesting in late pregnancy has been introduced since 1 year to capture late HIV transmission among pregnant women. Furthermore, the husband partner is encouraged to come forward to get tested at the earliest. Furthermore, a national HIV testing services and policy has been developed in 2020, and this led to the introduction of the HIV self-test and directly assisted HIV self-test. The law has been amended to allow HIV self-test and directly assisted HIV self-test and for same to be available to the public in private pharmacies. Through HIV self-test, it is expected that more people will know their status and be linked to care. The HIV and AIDS Amendment Act 2023 was approved by the government and published in the Government Gazette on Wednesday, 29th March 2023. The core principles essential for all HIV testing services are consent, confidentiality, and counseling. Pre-test to enable the person to be tested to make informed decisions. Post-test counseling, correct test results, and connection to HIV prevention, treatment, and care. Mr. Speaker, sir, you wish to note that funds to the tune of about USD 58,000 for the purchase of the first batch of HIV self-test is available under the present Global Fund Grant 2021-2023. Currently, procurement for HIV self-test is in process through the Global Fund pooled procurement known as WAMBO, as per the conditions laid down by the Global Fund. Specifications for the HIV self-test have been worked out by the Central Health Laboratory, which will carry out quality assurance of all HIV tests being procured. All procurement processes in this instance are under the purview of the Global Fund. My ministry is expecting to receive the details of the first batch of HIV self-test and shipping documents early next week, as per the latest update from the Partnership for Supply Chain Management of the Global Fund. Clearance from the Mauritius Revenue Authority and release from the Pharmacy Board have already been granted. Once the HIV self-tests are obtained, They will be available at the HIV service delivery points and distributed free of charge as and when required in our daycare centers of the AIDS unit. Mr. Speaker, sir, directly assisted self-test will be carried out upon request of those interested. Capacity building of healthcare and non-healthcare workers providers will be carried out on delivery of the test. In the meanwhile, private pharmacists will be empowered in carrying out HIV self-test and directly assisted HIV self-test. Private health institutions, including private pharmacies who wish to undertake HIV self-tests, will have to be registered at my ministry and the pharmacy board for the procurement of HIV self-test. Private pharmacies will procure HIV self-test as per their own procurement procedures. However, quality assurance of all the tests will be carried by the Central Health Laboratory of my ministry. The guidance for undertaking HIV self-test and prescribed guidelines for application of HIV testing, including self-testing, is currently being developed. Furthermore, the guidelines on HIV self-test and partner notification in the Republic of Mauritius is being elaborated for implementation. Mr. Speaker, sir, you wish to note that a workshop has been scheduled for 28 October 2023 in collaboration with the Association of Private Pharmacies. The audience will take cognizance of the HIV and AIDS Amendment Act 2023 and will be capacity built in conducting HIV rapid diagnostic tests with the collaboration of the Central Health Laboratory. As regards to part A of the question, I wish to point out that the issue of regulating selling price of the HIV self-test is not under the purview of my ministry. As far as part B is concerned, it is understood that only after the training of the private pharmacist has been completed that they would express their interest in selling HIV self-test and register with my ministry. Permit to import would then be granted by the relevant department of my ministry.
Merci, Monsieur le Président. Comme vient de l'affirmer l'honorable ministre, le HIV and AIDS Act a été amendé en mars de cette année. Et selon les récentes statistiques rendues publiques par l'ONG PILS, on peut constater qu'il y a une augmentation des cas positifs. Donc, si j'ai bien compris la réponse de l'honorable ministre, les self-tests, HIV self-tests seront disponibles dans un proche avenir. Donc, peut-on savoir pourquoi jusqu'à présent, il n'y a pas eu de formation, de training pour ceux qui seront appelés à encadrer justement les utilisateurs de ces self-tests? Pourquoi il n'y a pas à ce jour de formation qui a été dispensée et pourquoi il n'y a pas de cadre approprié qui a été défini jusqu'à présent par rapport à ce qui sera fait dans un proche avenir?
Mr. Speaker, sir, in the first part of the question, that's true to say that yes, there has been rise in the HIV test, that is positive test, but at the same time, the number of tests carried out, the policy for testing has expanded. And it's very important to note that at present, it's not only that the key population are targeted. At now, the HIV epidemic has also gone in the heterosexual, that's where the target has to be made, how the test will be carried out. And I believe the honorable member will share with me that how it is difficult to even do pre-counseling about testing. And that has to be done stepwise, with the law has been amended, and we haven't yet received the first batch of the test. So far, we ourselves, we should know how these tests being carried out. We have to empower. And after that, the training will be conducted. And obviously, that takes some time. And we have to understand that it can't be that we give license to anyone to start importing tests, and which would be out of the control. And we have to ensure that the pre-counseling, the counseling is done well, properly, before we introduce these self-tests. And can you imagine if we don't do that, what would be the impact in houses, in families where one person is tested positive? So it will require a proper pre-counseling before introducing these tests, and that's how the ministry is proceeding with the testing, that is the self-testing.
Peut-on savoir à ce stade si l'honorable ministre est en mesure de nous dire quelles seront les dispositions qui seront prises afin de garantir que les personnes dont les tests sont positifs pourront bénéficier d'une orientation adéquate vers les soins et par rapport au soutien aussi afin de renforcer l'accès au traitement?
Yes, Mr. Speaker, so I think if you will read the HIV Act, it is clearly stipulated in the Act how the testing should be done, that is the counseling, the pre-counseling, especially about the testing, and as well as the channeling them to the treatment, to the different AIDS department that we have across the island. So there is a proper guidelines for doing the test as well as offering the treatment. So that has to be followed as per the HIV and the AIDS Act that we recently amended to only include the self-testing issues.
The table has been advised that the following PQ, B 1243, has been withdrawn. Honourable members, I suspend the sitting for an hour and a half.